Hi, this is Mike Young, your estate planning and probate attorney in Walnut Creek, California. And I'm going to discuss with you basic estate planning and then some advanced estate planning. So when I meet with clients, we review three basic questions. The first one is, what happens if you die? The second question is, what happens if you don't die and you become ill along the way? And the third question is, what happens if you don't die and you suffer from dementia or Alzheimer's disease? So the first question, what happens if you die? We want to create an estate plan that makes distribution of your after you pass away as easy as possible. We want to choose the correct fiduciaries like a successor trustee under your revocable living trust who will step up and help make the distributions. With regard to this question, what happens if you die, we want to make sure that we do everything we can to avoid issues or fights among family members and others when you pass away. So the next question, what happens if you don't die, so to speak, and you become ill along the way? So modern estate planning concerns what happens if you die, distribution of assets, but what happens if you don't die and you need care during your lifetime? Your estate planning documents should have provisions in them for your care. Who is going to care for you for various levels of care, like in-home care, boarding care, assisted living, and skilled nursing, which involves Medi-Cal, which we'll get to a little bit later. So we want to identify what sources of assets you have that can be utilized for various levels of your care. Medi-Cal involves skilled nursing, and the idea is to get the state under Medi-Cal to pay for your stay, or at least the biggest portion of it, in a skilled nursing facility if you ever have to go to a skilled nursing facility. And I will discuss more about that in a few minutes. The last question, what happens if you don't die and you suffer from dementia or Alzheimer's disease? So this planning and this issue is a big part of my practice. When I meet with clients, I need to make a determination the best I can as to what their level of competency is and how we're going to make the plan accordingly. So a lot of times I'll discuss my elder care journey chart with my clients, and even if I don't, I have this in mind, this continuum with my clients. So at the far left of this elder care journey, you'll see the designation of a healthy, vigorous senior. And that could be a person of any age, good health, good mental capacity, and it's a pretty good wide range of things that I can do as an estate planning attorney and asset protection attorney for them. Farther along, I want to know, have my clients been on medications, and are they suffering from any acute health problems? As we go farther along to the right of this chart, planning becomes a little more difficult. We can always do planning, but the healthier my clients are and the better their mental capacity is, the more I can do. But I need to know about medications, any acute health problems. The next rung is hospitalization. Have my clients been, or have you been, in and out of the hospital recently? The next step, this is the danger zone, declining senior with memory or mobility issues. So it's a danger zone for me as the estate planning attorney, because I need to make sure that my clients have sufficient mental capacity to enter either into a basic estate plan or an advanced estate plan, which includes asset protection for Medi-Cal and government benefits planning. Sometimes, if I understand that the client is suffering from maybe a mild cognitive disorder, but they seem okay to me, I will get a doctor's note that says that this individual indeed has sufficient mental capacity to enter into the kind of estate plan I want to. And part of this approach is to protect everybody, to protect my clients, to make sure we don't have fights when somebody passes away, to make sure that we don't open the door for any potential attacks on any of the estate planning documents. So once we get the estate plan in place, or as part of this estate plan, we talk about how we are going to pay for various levels of care. For instance, in-home care, in-home assistance is usually the first level of care that people need to be taken care of in their home. And this is usually paid for by private pay. You pay for it yourself. Some people have long-term care insurance policies. The next step is assisted living facility. And assisted living facilities these days have, a lot of them have dementia wings, and they're more expensive, of course. Farther along, we have the fragile senior who is a nursing home residence. So if my clients are in a skilled nursing facility, that is the most expensive level of care generally. And that's when we want to look at Medi-Cal. So skilled nursing facilities are running about $10,000 to $15,000 a month or more from what I have seen. So the goal is to get people qualified for Medi-Cal if we can. So when I meet with my clients, a lot of times I will put up on a big whiteboard that we have in the conference room, this schematic. And I'll talk about my clients and I'll put their names in the schematic. If we're not meeting in my office and we're meeting remotely, like through Zoom, I'll use this chart or something like this. So let's say Bob and Mary come in to see me. They're a married couple, and we're doing estate planning. I'm doing their estate planning documents. And we discuss the revocable living trust as the centerpiece of their estate plan, which is true for most people in California, whether it's a single person like Mary or a married couple like Bob and Mary. Their home is usually the centerpiece of their estate plan. So in this estate plan, I have the home, I have Bob and Mary's home transferred to their revocable living trust. So let's say we have on the record for the home, Mary and Bob Smith, husband and wife, as community property. And I create their revocable living trust. I will create a deed from Mary and Bob, husband and wife as community property, to Mary and Bob as trustees under their revocable living trust. So now on the record, the home is in the trust. The title at the recorder's office shows that it's in the trust. So typically, let's say if Mary dies, the home stays in the trust and Bob takes title. When the second spouse passes away, who would be Bob, then the beneficiaries take title. And they could be the three children I have, Lisa, Frank, and Jack. So let's say Mary is a single person and she's transferred her home into her revocable living trust and she dies. Then by operation of the terms of the trust, the home goes to the three children. So we have no probate court, no court involvement. If Mary passes away first, there are just a few things that we need to do, but not much, and no probate court, no court involvement. So let's say also Bob and Mary transfer, they have a joint Schwab account. These are just numbers, but let's say it's $100,000 and they transfer that into their trust. And let's say they have a Fidelity account for $100,000. They transfer that into the trust. So the same idea, if Mary passes away, the Schwab and Fidelity accounts and the home stay in the trust for the benefit of Bob. When Bob passes away, Lisa, Frank, and Jack, one of them will step up as trustees and transfer the property to them. So as part of the estate plan, we have IRAs and 401ks. So let's say Bob has $300,000 in IRAs. We do not transfer the IRAs or other so-called qualified accounts into the trust. So IRAs, 401ks do not go in the trust. You name direct beneficiaries for them because there are adverse tax consequences if you transfer retirement accounts into the trust. So we have the home, we have Fidelity, we have Schwab in the trust. Outside of the trust, we have Mary with $300,000 in IRAs and Bob with $300,000 in IRAs. These are just examples. So when both Mary and Bob pass away, Lisa, Frank, and Jack take the assets that are in the trust, and the beneficiaries of the IRAs go to the named beneficiaries, who are probably also Lisa, Frank, and Jack, the couple's children. In the revocable living trust, we include, so the overlay, so that's the basic estate plan, what happens if you die. But the overlay on top of the estate plan, which is coordinated between the revocable living trust and the financial durable powers of attorney, are care provisions. Who's going to care for my clients? Where is the money going to come from for their care, for various levels of care? Dementia provisions. If they lose capacity, if either of them lose capacity, under what circumstances are the named successor fiduciaries going to step up, either through the trust or the financial durable powers of attorney? And we have Medi-Cal asset protection provisions, which are coordinated between the revocable living trust and the financial durable powers of attorney. So I'll show you a little bit later, but basically there's a handshake, the connection between the revocable living trust and the financial durable powers of attorney for asset protection provisions. So you'll see that, so we'll talk a little bit about Medi-Cal qualification. So let's say we have this nice modern estate plan, everything is updated, language coordinated between the revocable living trust and the financial durable powers of attorney for care and for asset protection and for Medi-Cal planning. And let's say we have this couple, Mary and Bob breaks his hip. And so Bob has to go to the hospital, John Muir Hospital or Kaiser Hospital, and he's having complications. Let's say he's at the hospital for 3 nights, and then he's discharged to a skilled nursing facility. So he's in the skilled nursing facility, and Medicare for an older person will pay at first, usually for the first 20 days. And the skilled nursing facility, a lot of times will say, the patient, Bob, has plateaued and is no longer improving as far as the care that they can give him. So they want him basically to discharge himself. But let's say Bob really needs that level of care in the skilled nursing facility, and his medical doctor says that he really needs to stay. And Mary says, I can't take him home. I can't take care of him. You know, Mary's having issues herself. So Bob needs to stay. So what are the options for a payment of $10,000 to $15,000 a month for payment for Bob? So there's private pay. Does Bob have pockets of money that can be used for his care? If he starts using that money at 10 to 15 grand a month, it's going to take assets away from Mary that she might need at some point in time. So let's say we just have a single person, Mary, and she breaks her hip. She's at John Muir Hospital, and then she's discharged to a skilled nursing facility. Medicare pays it first, usually up to 20 days. You can appeal it up to 100 days. And then she has to private pay, or maybe she has long-term care insurance, but we will want to look at Medi-Cal as a possibility for payment. So let's take a look at my Medi-Cal desk reference for 2020. And let's assume that we're applying for Bob for Medi-Cal to pay for his stay in the skilled nursing facility. So one of the first questions on the Medi-Cal application is, Bob, do you own a home? Yes. And we identify the home. And Bob, do you intend to return home? Yes, I intend to return home. Even if I have to go to a skilled nursing facility, it's always my intent to return home. So I have that language in the estate planning documents, and I have a separate statement. And what Medi-Cal wants is a subjective intent in writing to return home, to make the home exempt as an asset for qualification for Medi-Cal. So let's say, and these are under the present rules, which may change, but I build in language to be able to accommodate to any changes in the law. But presently, let's say there's a home, fair market value of $1 million. Bob intends to return home. The home is exempt as an asset for qualification for Medi-Cal. Then the next question is, Bob, do you have any IRAs? Yes, I have $300,000 in IRAs. And you're married, Bob, to Mary. Does Mary have any IRAs? Yes, she has $300,000 in IRAs. So now we report all of that to Medi-Cal, the home, the intent to return home. Bob's $300,000 and Mary's $300,000, and all of that is exempt for qualification for Bob for Medi-Cal. $1 million home and $600,000 worth of IRAs between the two of them. So then you'll see this $2,000 figure mark. Bob cannot have more than $2,000 in his name on any asset with his name on it, other than the IRAs. Let's say we just have a single person, Mary, and we're qualifying her for Medi-Cal. She cannot have more than $2,000 on any asset in her name. So now Bob cannot have more than $2,000, but there are two joint accounts in the revocable living trust. The Schwab account for $100,000 and the Fidelity account for $100,000. Now, to get Bob qualified for Medi-Cal, we need to transfer the Schwab and the Fidelity accounts from Bob to Mary. So if Bob has good mental capacity, he can sign all the documents. So the word for this is transfer. So Medi-Cal calls transfers of assets between married couples, not as gifts, but as transfers, and there are no penalties. Now, let's say that Bob has lost mental capacity. He does not have sufficient capacity to transfer the Schwab and the Fidelity accounts to Mary. So where do we get those? Where do we get the authority? Mary is Bob's fiduciary. She's the successor trustee under the revocable living trust, and Mary is Bob's attorney, in fact, under Bob's financial power of attorney. Now, does Mary, as Bob's fiduciary, have authority, generally speaking, to transfer Bob's interest in the community property assets to herself without consideration going back to Bob? No. 99% of all estate plans that I have ever seen do not allow for that. So we need specialized language that is coordinated between the revocable living trust and the financial durable powers of attorney to allow for this. So it becomes complex, but I mentioned the handshake between the revocable living trust and the financial durable powers of attorney. So we confirm that Bob has lost capacity. We have triggering language in the trust and in Bob's financial durable power of attorney, which allows Mary to stand into Bob's shoes as if she was Bob as settlor under the trust, to transfer Bob's community property interest in the trust accounts to her without consideration going back. So that's the handshake. So there's specialized language that is coordinated between the revocable living trust and the financial durable powers of attorney. Let's say Mary is a single, and so when we transfer Bob to Mary, Mary can have up to $128,640, and Bob will still be qualified for Medi-Cal. So Bob can have his IRAs, Mary can have her IRAs. Bob can only have $2,000, but Mary can have up to $128,640. What if Mary has more than that? What do the Medi-Cal rules allow? And this gets stickier and more complex, but we follow the rules precisely and take advantage of them. So if Mary has too much, she can spend the money on anything, on the house, put a new roof on the house, update the landscaping. She can gift money to her children, maybe Lisa, Frank, and Jack, but penalties can occur. Don't try this at home. Call me or your estate planning attorney, your elder law attorney to figure out how to do this. But gifting is still allowed. We still have a 30-month look-back period. And I can tell you more about those very specific rules at another time. I can go to court and I can petition for findings from the court under a federal statute, which would allow Bob and Mary to keep all of their assets. The federal state shall create Medicaid, which is Medi-Cal laws, which would make the well spouse become impoverished. So presently the home, so she can spend, transfer, gift. If she's a single person, she can still spend, not transfer, but gift to the children and go to court. Another thing she can do is get an intermediate single premium annuity to create a income stream to her, but that gets more complex. So now let's say we've moved all that money over to Mary. We've gotten Mary down to $128,640. We're making sure that Bob does not have more than $2,000 in any account by the end of the month, and then we get Bob qualified for Medi-Cal. So the other part of this is share of costs. The share of cost is the money that Bob has to give to the skilled nursing facility. And the rule is that Bob's income goes to the skilled nursing facility. And Bob gets two little deductions, $35 for incidentals and basically his Medicare Part B premium. So if he's a single person, that's the rule. His income from all sources, Social Security, pensions, required minimum distributions from his qualified plans, all go to the skilled nursing facility. But let's say Bob and Mary are married. In this case, we're qualifying Bob for Medi-Cal. Mary gets to keep all of her income, no matter how much it is. And there's a floor for that of $3,216. Mary gets to keep all of her income. Bob's income goes to a share of cost of the nursing home. If Mary makes less than $3,216 a month, then in the accounting we provide to Medi-Cal, we take away from Bob's income the amount that would bring Mary up to $3,216 per month. These are very basic rules. Now, the other side of the coin is, let's say Bob was in a skilled nursing facility, he was on Medi-Cal, and he passed away. The state will want to find out what was in Bob's estate when he passed away so they could follow a lien on it and eventually get paid. If Mary's still alive, they won't pursue against Mary while she's alive. Let's say Mary's gone, Mary passed away, Bob died, Bob was on Medi-Cal. In my office, so we got Bob qualified for Medi-Cal, then we will get a letter from Medi-Cal and it will say, Mr. Young, were there any assets in Bob's estate when he passed away? Because we want those assets. So as of January 1st, 2017, Governor Brown signed into law the law that says that basically part of it, if your home is in your revocable living trust when you die, the state cannot glom onto it. They cannot attach it. Because the home, by operation of the terms of the trust, go to Lisa, Frank, and Jack. Now, there's a bill in the state legislature which could change that. And if that happens, I have built into my estate planning documents the language I mentioned, which would allow us to move Bob's interest in the home over to Mary. So Bob intends to return home. The home is exempt. Bob has lost capacity. Mary can actually transfer Bob's interest to her. So I build in to the estate planning documents provisions that will allow us to accommodate to the law if there's a change in the law. So I'm getting kind of complex here, but basically, so these are the estate planning documents that my clients have when they leave my office. So we have property management, durable powers of attorney with Medi-Cal and asset protection planning provisions. And that's what I spoke about regarding the handshake between the powers of attorney and the trust. So we coordinate with the trust. Powers of attorney, so we have a power of attorney, powers of attorney between Bob and Mary. Bob and Mary have been made 40 years. Am I going to prepare the power of attorney so that the powers come into existence when Bob has lost capacity based upon 2 letters from doctors? No, why would I do that to them? I make the powers of attorney usually effective immediately so that Mary can stand into Bob's shoes. We also have advanced healthcare directives that coordinate with the power of attorney. I'll show you that. So the centerpiece of the estate planning documents is the revocable living trust with Medi-Cal and asset protection provisions and also care provisions, instructions that you want to return home, etc., how you want to be taken care of, statements like I want to maintain independent living as long as I can. If my clients have an existing revocable living trust, I will almost always do an amendment and restatement of the trust. So I update the trust. So the amendment and restatement of the trust keeps the trust name, keeps the date of the trust, and it states that all assets that have been transferred to the trust remain assets of the trust. I also look for any mandatory AB bypass provisions. So we usually want to get rid of them because they create issues, Medi-Cal wise and otherwise. So take a look at your revocable living trust. If it's a 20th century trust, more than likely it will have a statement in there between spouses that when one spouse dies, the assets will be split. Half of it will stay in the revocable living trust for the benefit of the surviving spouse, and the other half will go into an irrevocable trust for the benefit of the decedent spouse. And this basically was all set up for death tax purposes, to save on death tax. The death tax exemption amount now is up to, I think it's $11.2 million per person. So I discussed this issue with my clients. There may be a reason to keep that mandatory AB bypass trust in there, and we can discuss that. We prepare a certification of trust. So the certification of the trust basically is, think of it as a Reader's Digest version of the revocable living trust. So the concept is that if you are going to do trust business, like transfer an asset to the trust, transfer your home to the trust, the financial institution or the title insurance company need only look at the certification of the trust. So it has the name of the trust, when the trust was created, the makers of the trust, who are the settlors, and the basic powers. And the idea is to protect the right of privacy of the makers of the trust. The world does not need to see all the family issues in the trust. Financial institutions, a lot of times, will want to see the first page and the signature page of the trust. So there are two healthcare forms: advanced healthcare directives and HIPAA statements. So HIPAA statements, we name, so for instance, we have John and Mary. John names Mary and the 3 children and gives them a specific authority to give John's healthcare documents and records to another healthcare provider or to a healthcare insurance company. And John Muir Hospital and Kaiser Hospital are real sticklers about patients having HIPAA statements so that family members and others can have access to medical records. The other document is the Advanced Healthcare Directive. It makes reference to the California Probate Code. Attorneys have kind of been told over the years not to create your own healthcare powers of attorney, because the healthcare community is used to seeing the Advanced Healthcare Directive. It's connected to the Probate Code. It's very explicit. It's a familiar form. It has the, I rudely call, pull the plug provisions in it. I separately do declarations of intent to remain home. So these declarations of intent to remain home do two things. One is they give an instruction to the family and to other caregivers that if my client becomes ill, they want to return home, be taken care of at home, and stay at home. And it has been shown that people who stay at home and are cared for at home do better for a longer period of time. I also map Medi-Cal language. So Medi-Cal, to make the home exempt as an asset for qualification for Medi-Cal. So the state wants to see a subjective intent in writing by the Medi-Cal applicant to return home. So once my clients sign that document, the home is exempt and we have freedom to do things with the title. If you haven't come to see me or another elder law attorney and we're, for instance, filling out a Medi-Cal application, we can always check the box that Bob intends to return home. So I get arguments about that from clients, and the intent to return home is what makes the home exempt as an asset. So I'll get arguments from clients. No, Mr. Young, I don't think I will want to return home because I don't want to be a burden or whatever reason. And I'll tell them, just forget about that. Just listen to me. Sign the declaration. So then we have pour over wills. So there will always be wills, two wills, one for each of the couple, Bob and Mary. If it's just Mary, for instance, there'll be one will. You will not see the term pour over in the will. That's a vernacular for the will. And what it means is, let's say Mary dies and an asset pops up, and for some reason, no beneficiary was named. Maybe it's a Schwab account or that Fidelity account we spoke about. Either no beneficiary is named because of some mistake, or it's not in the trust. Then I can file a petition with the court to get a decree of distribution pouring that account back into the trust. Another document for couples is a community property agreement. So I have a general community property agreement that I create that says between a married couple, I mean, if this is applicable, that all of our assets are community property, even if we took title as tenants in common or joint tenancy. So a lot of clients, husbands and wives, will take title on their deed as joint tenants. 99% of the time it should be community property. This is a capital gains thing. We want a full step up in basis. So looking back at the revocable living trust, if I have a couple, if Bob passes away first, let's say, Mary will take title with a full step up in basis, meaning she'll get fair market value of the property as of the time of Bob's death. Mary could turn around and sell the property right away without worrying about capital gains. On the second death, the children get a second step up. So Lisa, Frank, and Jack get another 100% step up in basis. No capital gains if they want to turn around and sell the property right away. If Lisa, Frank, and Jack want to keep the property, I prepare a Prop 58 request. That's a form that tells the assessor that Lisa, Frank, and Jack are the children of Mary and Bob, and that Lisa, Frank, and Jack should be able to keep the Prop 13 basis and payments that their parents had. So deed for the home to the trust, preliminary change of ownership report. So this is kind of the basic estate plan, the advanced estate plan. Of course, usually there are a lot more nuances and issues and complications, and sometimes these estates become very complex about who gets what, when. We can have special needs trusts for special needs children, to protect their assets so that they can keep their government benefit planning assets rather. Sometimes we have resulting trusts for children or grandchildren. Those trusts can last for years, and we can protect assets for children. Grandchildren, protect them from themselves. In some instances, have a fund for school, for tuition, that sort of thing. So feel free to give me a call. I am Mike Young, estate planning and probate attorney in Walnut Creek. You can go to my website for more information, walnutcreekelderlaw.com, or you can give me a call at 925-256-0298. So thank you for listening.